So welcome everybody this afternoon to In-House in Focus. I'm your chair for today's session. My name's Alex Newman. I'm an intellectual property lawyer here at Mills Reeve. And as always, for the chair, I have two jobs to do today. Firstly, and most importantly, I'll be introducing you to our speakers and very briefly introducing today's topic. I'll also be covering the housekeeping, which those of you who are familiar with these sessions will have heard many times before. As ever, I apologise if you're hearing it for the 100th time. So, some introductions. As I mentioned, today is a transatlantic collaboration between Mills Reeve and our friends from Mintz, which is a large full-service US law firm headquartered in Boston. So, it's our pleasure to be joined today by Arameh O'Boyle, who's a litigation member at Mintz, and Paige Adaskaveg, who's an associate in Mintz's litigation section. Arameh and Paige's practices focus on defending manufacturers across the US in complex product liability and consumer class action litigation, as well as advising clients on product labeling and advertising strategies to navigate US regulatory requirements and mitigate legal challenges under various states' consumer protection laws. From Mills Reeve, we welcome Katrina Anderson, who will be a familiar face for many of you. Katrina is a regulatory lawyer who advises clients on compliance with regulation which touches on their relationships with consumers, including labeling, advertising, digital, and e-commerce regulation. And today, Arameh, Paige, and Katrina will provide a transatlantic perspective on consumer protection law and enforcement. So I'll hand over to them in a moment, but first some housekeeping. As ever, there will be a recording of this session available later. It will be uploaded as soon as possible to the Mills Reeve In-House in Focus YouTube page, and you'll all be able to find that very easily if you want to. We will be doing Q&A at the end of the session. Could I ask you all, please, if you do have a question, please use the Q&A button at the bottom of your screen. Please type your question into the Q&A function. I will then field and put as many of those questions as possible to our panel at the end of the session. Please don't use the chat function, or they won't see it. I won't see the questions. Please use the Q&A function instead. If possible, if you could mention when asking the question which of the slides your question relates to, that will make it much easier for our speakers to understand the context of the question. Also, if you could include your name while putting a question, that would be helpful. I won't disclose your name to whoever asked the question to the other attendees, but it means that if we don't get around to answering your question during the session, we should be able to respond to you directly afterwards. And finally, and very importantly from our perspective, please do complete the feedback form at the end of the session. Please let us know whether what you heard was of interest, and please do, again, as we always ask, suggest any topics you might like to hear about in the future, because it does make our planning sessions much easier if we know what it is that you want to hear about. So that's plenty from me, more than enough. I will hand over now to Arameh, to Paige, and to Katrina to tell you all about it.
Thank you, Alex. Thank you, everyone. I guess I will kick this off by starting with a little bit of an intro of enforcement of consumer protection laws in the United States, where Paige and I practice. So the first question to ask for us is, who enforces consumer protection laws in the United States? And here in the US, the laws are enforced by a multi-layered system that includes various federal agencies, state authorities, and most notoriously, probably, and aggressively, the private actors that I'm sure you've all heard of, and that would be the plaintiffs' attorneys who bring class action litigation in the US. But starting off with the federal agencies, there are several different agencies that enforce consumer protection laws. The FTC is the most visible enforcer in this space. It governs everything from green claims to influencer marketing. Its actions set the tone really nationally for what is acceptable in advertising and product labeling. Lately, we've noticed some of the areas of focus for the FTC have been truth in advertising, endorsements, online reviews, green claims, marketing by influencers, and made in the US claims. Some of those we'll cover here in this presentation today. We also have the FDA, which governs cosmetics, food, drugs, dietary supplements, and medical devices and pharmaceuticals. The FDA ensures that what you put on a label for these products is accurate and not misleading. Its most common enforcement tools are the dreaded recalls, but also warning letters. We also have the CPSC, which functions similarly to the FDA, but it's especially active in categories including toys, electronics, household appliances. And similar to the FDA, it also has mandatory reporting requirements and recall authority. We also have the EPA, which is very active in some critical areas right now, including PFAS, recyclability claims, and other green claims like eco-friendly. Next slide, please. We also have state enforcers in the US, and more we're seeing our state attorney generals acting as very powerful enforcers of consumer protection laws. California's attorney general in particular is always a leader in these areas. California is where Paige and I practice, and it's a very exciting jurisdiction to be in. But violations of any statute can actually, in the US, trigger enforcement from multiple states at once. State attorney generals will frequently band together to bring what we call a multi-state action against a company. As I mentioned, we also have our private enforcers, and that's the plaintiff's attorneys. That's probably the biggest difference, I would think, between the US and the UK, is that we have a very aggressive and well-funded plaintiff's bar. They are often the most aggressive enforcers in this space, especially in California and New York. And so consequently, civil litigation has to be a major consideration for anyone entering or considering entering the US market. Because oftentimes, regardless of whether or not a lawsuit brought by a private actor is meritorious or not, class action lawsuits can be extremely costly and harmful to companies. We also see enforcement by competitors. They can bring complaints to the National Advertising Division against a competitor, or they can bring litigation for false advertising under what's called the Lanham Act. In fact, very recently in California, two competitors were in private litigation against each other in the energy drink space under the Lanham Act, and a California jury awarded one company $311 million in damages against their competitor because the competitor was falsely advertising some fake ingredient in its product. That 311 happens to be the largest Lanham Act award in history, but it illustrates that it's a very real threat here in the US. And then there are other enforcement areas. We have, like I said, the NAD. We have also the Better Business Bureau. They all provide sort of non-government oversight. They help companies resolve disputes before they escalate. And if they can't resolve the disputes, then those usually end up back in front of the FTC or in private litigation. Next slide. One of the most challenging aspects of the US system in our regime is that it's multi-layered. Enforcement by one agency or a group or one private actor is not exclusive. In the event of an alleged violation, multiple enforcement channels can be triggered. So you're not just dealing with one agency or one type of action. You might get hit from multiple channels. Sometimes it's simultaneous. Sometimes it's a chain reaction. As an example, if your advertising is alleged to contain a potentially misleading environmental claim, you could be hit with an FTC enforcement action. And then at the same time, the plaintiff's bar, which is always trolling, the government websites, they might follow on with a class action lawsuit, which might get the attention of the state attorney general's office. So all of a sudden, you might be dealing with with investigations and lawsuits from all sides, or it's possible that it might not all happen at once. They may gradually trigger each other. Similarly, an FDA recall or a warning letter or a recall from the CPSC could trigger a consumer lawsuit, which may then lead to scrutiny by the state attorney generals. Importantly, in the US, if you settle with one agency, one regulator, or one private party, it doesn't protect you from claims from all the other avenues that we talked about. And the only exception to that would be class action litigation. If you settle on a nationwide basis, then other consumers would be precluded from bringing the same type of litigation against you. But this type of, snowball legal exposure that we look at here on this slide, that can be incredibly costly to defend. And like I said, it could have a devastating impact on a brand. So for these reasons, in the US, it's really essential to build a cross-functional compliance program so that you have a strategy in place to make sure that you are complying at all levels, federal level, state level, and private enforcement. Next slide, please. And I think that's Katrina.
Thank you. Well, I just wanted to give you a little bit of a contrast of how it works in the UK, because probably the biggest difference, which Arameh has already really touched on, is that our enforcement of the rules in the UK is primarily through regulators. So we don't have this same dynamic of enforcement coming from lots and lots of different places at the same time, or necessary cascade effects, because generally speaking in the UK, even if multiple regulators can enforce, they will normally agree among themselves behind the scenes. That actually who is going to take the lead on enforcement. So you will normally be dealing with one regulator only in relation to a matter. And also, we don't typically have private enforcement by competitors in quite the same way. And while it is possible to have class actions in the UK of affected consumers, again, it's not normal. So the primary thing is regulatory investigation, which is not by any means to suggest that regulatory enforcement is the easy option, or if you happen to be caught up on it, it's going to be an enjoyable experience. It will vary by the type of regulator that you're involved in. So we have different regulators that have sort of somewhat overlapping jurisdictions in the consumer protection and advertising space. So we have the Competition and Markets Authority, who is tasked with, if you like, strategic public policy focused enforcement. So they will take a theme, something that they are concerned about, and run what's called a big market investigation, which will likely ultimately result in some high profile enforcement. So a good example of that would be something like green claims, which we're going to talk about as one of our hot topics later. They can enforce in relation to pretty much everything. They have a wide remit. If consumers are in the mix, it doesn't matter whether it's your advertising, your labeling, they will look at the whole lot. In contrast, we have the Advertising Standards Authority, which, clue is in the name, they're all about advertising. But it's worth noting that advertising in this context is a little bit wider than you might classically think. It's not just your classic broadcast advertising, but it would, for example, include your own website. It would include everything you do on social media, and a lot of kind of digital channels. So their focus would be on that kind of content. And then we've got trading standards, which is a kind of network of local regulators. So each kind of city, or in the case of London, part of London, has their own trading standards. And they can also look at everything, but will quite often focus on things that are out of remit for the ASA. So there's a bit more of a focus on labeling by trading standards, because the ASA would not normally look at labeling. But again, they're doing the kind of the day-to-day enforcement. And the enforcement here, although, the big stick, if you like, is that ultimately most consumer protection laws are criminal offences in the UK. So ultimately, criminal prosecution of a company or an individual is a possibility. But in reality, mostly this will take the form of a protracted investigation followed by agreeing some kind of package of remediation. So, the regulator will be mainly looking to agree with you that you will change your label, take your product off the market, amend your advertising. And they will be quite strict in that, but provided you are somewhat cooperative with that, usually something short of criminal prosecution can be avoided. It is also worth noting that if you are in a specifically regulated sector, so for example, life sciences, food, energy, anything like that that has its own body of regulation, there will also be sectorial regulators who will look at these things as well. In the UK, mostly in the past, we used to say that enforcement was triggered by complaints. And that would either be complaints by your competitors, so they would go along to the regulator, having sometimes complied with an initial process where they have to notify you first and say they think there's an issue, or there would be a complaint by a consumer. So we would tend to assess the risk of regulatory enforcement essentially by, is it likely that anyone's going to complain about this issue? But over the last few years, we've seen regulators adopt much more proactive approaches to regulation. And this has really been brought about by the use of AI. So at the absolute forefront of this, we have the ASA with their active ad monitoring system. And what they do is, in what they call a policy area, they will actually switch on this tool they have, which scrapes the internet looking for problematic claims. So if you're making your claims in any kind of digital, be that social media on your own website, you have to factor in to your risk profile whether or not this is a policy area for the ASA. But increasingly, we're seeing other regulators are picking up on AI as well. So we know, for example, the Competition and Markets Authority is already using it in other areas like public procurement, and we think it's only a matter of time before they're going to use it in consumer protection. The other risk factor that's really important to bear in mind is, as I mentioned previously, the Competition and Markets Authority is very policy led. And that can either be sometimes they will receive almost direct instructions, sometimes from government. So we've got an investigation at the moment in dynamic pricing, which was very much triggered by government. Sometimes it can be something called a super complaint, which is where one of the consumer protection organization makes a complaint. Or it can be that it's in line with their own kind of policy focuses about where they think there is particular consumer harm. So if what you're looking at fits into one of those policy issues, then that will also go to the risk of enforcement in the UK. And this is particularly acute as of the 6th of April, because the CMA got new enforcement powers from the 6th of April, where they are now, in relation to consumer protection law, able to fine companies without going to court and criminally prosecuting them. They can still criminally prosecute if they care to do so, but in addition to that, they can fine you up to 10% of your group global turnover for breaches of consumer protection law and advertising rules.
So as Katrina mentioned, our first high risk area is greenwashing claims, which in the US in particular have been highly popular over the last several years, primarily led by consumer trends that have increasingly motivated companies to make claims of environmentally conscious products, commitments to environmentally friendly practices, and sustainability. Unsubstantiated green claims have been and likely will continue to be an enforcement priority for the US and state government agencies as well as private plaintiffs. High-risk claims include claims like recyclable, biodegradable, non-toxic, free of, sustainable, eco-friendly. Before making these claims, companies should confirm that the green claim about the product can be substantiated with competent and reliable scientific evidence, and should avoid general claims or qualified claims and to explain the specific environmental benefit that the product provides. And also companies should qualify claims to specify what they apply to. So for example, is the product's packaging recyclable or are its contents recyclable? The FTC has issued detailed guidelines about how to substantiate green claims and frequently brings enforcement actions for deceptive and misleading greenwashing claims. So it's important for companies to refer to and rely on those guidelines. The Securities and Exchange Commission also brings enforcement actions and levies fines for deceptive, misleading green claims made by U.S. investor funds. And additionally, several states have passed laws regulating greenwashing claims. For example, in California, there's the Truth in Recycling Law. And under that law, it places restrictions on recyclability claims and requires record keeping to substantiate environmental marketing claims. The law also prohibits the chasing arrows, which you see on the screen here. That symbol can't be used unless the product meets strict statewide recycling requirements. California also has an anti-greenwashing law known as the Voluntary Carbon Market Disclosure Law, which applies to entities that make claims regarding progress towards carbon reduction goals. For example, claims like a product is carbon neutral. The law requires disclosure of certain information on company websites, including how the carbon reduction claims were determined to be accurate or how the carbon reduction has actually been accomplished. And as Arameh mentioned, private class action lawyers also bring many lawsuits focused on these types of claims across multiple industries. For example, in early 2025, consumers of Gore-Tex outdoor gear filed a class action alleging that the company knowingly concealed its ongoing use of environmentally harmful PFAS, known as forever chemicals, in waterproof clothing and shoes. The company allegedly advertises that it's committed to sustainability and environmentally sound, and that its laminates were PFC-free and reflected responsible performance. The plaintiffs allege that these claims were false and misleading because the company used environmentally harmful PFAS in manufacturing. So although greenwashing claims have been around for several years now, they continue to be at the forefront of the plaintiffs' bar's agenda.
And green claims are similarly a very high risk area of enforcement in the UK. So from the UK perspective, we saw a really big shift. Well, initially in the September of 2021, we got some new guidance from the Competition and Markets, which was called the Green Claims Code. And unusually, they said that they were giving a 3-month grace period to everyone to get their house in order before they would commence enforcement. The grace period actually turned out to be a little bit longer than that, but then they kicked off their first market investigation into green claims, of which there have now been a series. And we know that they are working hand in glove with the ASA. They meet with them regularly. And as a result of these market investigations, we've now seen a tripling of the number of investigations into green claims since sort of mid 2022. And whereas previously, sometimes green claims, the complaints were not upheld, it is vanishingly rare these days that a green claim is not found to be problematic. And that's really because the regulators have made it clear that the level of substantiation they want to see for certain green claims is effectively beyond what most commercial companies could ever realistically say. So, for example, if you want to say your product is green or sustainable, you would need to have evidence across its entire life cycle. So that's from the ingredients or the components of your product being originally sourced to them being transported, manufactured, turned into a product, sent to a retailer, sold to a consumer, and ultimately end of life disposal. You would have to demonstrate across that entire life cycle that you have a net zero environmental impact, which is very, very rare for commercial goods. And it means that over time, we are now seeing a real shift away from what we call these absolute claims, so green or sustainable, to either mission claims, so I'm becoming greener or more sustainable, or claims that you are greener or more sustainable than you were in the past or your competitors. But even these have issues, and it is not broadly the case in the UK that these issues can be dealt with by means of a disclaimer or any kind of additional information on the label or packaging. It's more a matter of changing the claims themselves. So it remains a high risk area. We're waiting to see now that the CMA has got its new finding powers, whether it's going to launch another market investigation, and if so, which market that will be into. So far, it has looked at fast moving consumer goods. It's looked at fast fashion. It's also looked at some things like boilers and insulation. So we'll see where this goes next. But in the meantime, the ASA continues to enforce.
So our next high-risk area is California's Safe Drinking Water and Toxic Enforcement Act of 1986, commonly known as Prop 65. Prop 65 is a substantial threat to companies selling consumer products in California, including primarily food, dietary supplements, personal care products, and cosmetics. There are over 900 chemicals on the Prop 65 list that the state of California has determined may cause cancer, birth defects, or reproductive harm. If a product exposes a California consumer to any of the chemicals on the Prop 65 list at levels above the safe harbor, if there is one, the company must warn consumers. It's important to note that there's not a safe harbor level for all chemicals, and those recently have in particularly been a target of warnings or notices from plaintiffs' counsel regarding a chemical on the Prop 65 list. Failure to comply with Prop 65 can result in a hefty penalty of $2,500 per violation per day. And although Prop 65 can be enforced by the California Attorney General, district attorneys, or city attorneys, it is most often enforced by private individuals. And plaintiffs' attorneys are highly incentivized to bring Prop 65 lawsuits because the law permits them to recover attorneys' fees and costs. So Prop 65 requires plaintiffs to issue a notice of violation before filing a Prop 65 lawsuit. A response to these notices is required in 60 days. Otherwise, the plaintiff must initiate their lawsuit. And if you receive a notice of violation, you should contact counsel immediately to negotiate a resolution as soon as possible, because it's a lot easier and cheaper to reach a settlement before the lawsuit is initiated. Because once the lawsuit is filed, court approval is required for any settlement. And this process can be long and drawn out. Additionally, the Attorney General has the opportunity to object to a settlement, so it can be quite challenging in certain instances to reach a settlement once the lawsuit has been filed. To avoid Prop 65 litigation risk, companies should audit their products to assess risk and keep in mind that products may be contaminated with chemicals that are not knowingly added to the product during the manufacturing process, and test products to determine whether they contain any chemicals on the Prop 65 list. If you determine that a product contains a listed chemical, you should determine whether there is a safe harbor for the product and whether the level of exposure is below the safe harbor level, and if not, provide a compliant warning. Additionally, counsel should be consulted regarding providing Prop 65 warnings, because these can vary based on the types of products and are amended frequently by the state of California.
Another high-risk area here in the US is claims that a product was made in the USA. We call them made in USA claims, very original. And we're seeing a lot more companies making these claims about their products, which is probably not surprising given the political climate here. We're also seeing just more consumers looking for products that have been made in the USA. The actual claim itself is not limited exclusively to saying made in the USA. It could also be pictures of the USA flag or an eagle on your product, or references to a US location where your product is made. So we have the FTC has made in USA labeling rules that govern these types of claims, and the FTC rules allow for significant monetary civil penalties, I think up to over $50,000 per single violation of their rules. This is also a high-risk area, unsurprisingly, for consumer class actions. So under the FTC guides, which really controls how even plaintiffs' attorneys interpret whether or not you can make a Made in USA claim, there are substantiation requirements to make the unqualified, just Made in USA claim. The FTC requires a reasonable basis that all or virtually all, and that's really the magic language, all or virtually all of the product is made in the USA. That means all or virtually all of the ingredients, the materials, your components would have to be made or sourced in the USA. And importantly, the final assembly or the processing of the product must also occur in the USA. Recent FDA guidance provides that all or virtually all means that the product should not contain more than a negligible amount of foreign content. The guidance also specifically warns against making vague claims such as created in the USA or produced in the USA. Those are, according to the FTC, misleading on their face. Now, it's important to keep in mind that in the US, with the exception of a few industries like the auto industry and a few others, there's no requirement for a company to make US origin claims. So you don't need to disclose the amount of USA material in your product. Now, US custom law conversely requires every article that's of foreign origin to be marked with its country of origin. But if you're going to voluntarily make a US origin claim for your product, it's really critical to vet every use of the unqualified US origin claim on your packaging, on your websites, on your promotional material to ensure that those claims are accurate. If you are unsure, then we would recommend you use qualified claims, something like assembled in the USA with imported parts. We're seeing a lot more of these qualified claims here. And if you're modifying your supply chain, which again, given the unstable political and economic climate that we are in is more and more common, it's imperative that you continuously check your labels and check your claims to make sure they're up to date and match your supply chains. Next slide, please.
So in truth, this is a point in which there's a little bit of difference from a transatlantic perspective. I would not normally have picked out 100% British claims as a particular risk area, other than to say that in some regulated areas, such as food, there are quite specific rules about origin claims, but it is not a high risk enforcement area. There are no AI bots. As far as I'm aware, looking for these claims by any regulator, and it's not a particularly policy focus for us at the moment. That said, there is a rather nice case study of what can go wrong if you don't handle a regulatory investigation well. And this is about an individual butcher who presented beef, which was actually sourced mainly from South America and to some extent Europe, and sold it as 100% British and used lots of rather cute bunting with Union Jack flags on it to illustrate this point. He was criminally prosecuted, as was his company. The prosecution was successful. There was a significant fine of 300,000 plus costs, and he was personally given a prison sentence. Along with that criminal conviction. So this is, if you like, the big stick that exists with regulatory investigations in the UK, that along with the new powers of civil fines that the CMA has literally just acquired in the last few weeks.
Another hot topic in the US, and I think as Katrina will highlight, it seems also in the UK, is influencer marketing. Social media is only continuing to grow as a powerful marketing tool. So there seems to be no way for us to escape social media influencers like Mr. Beast and all the others. They're here to stay. The rule in the US is that if a brand is paying or incentivizing influencers in any way, so that's whether you're giving them free products or commissions or discounts, you must disclose that relationship. And the disclosure must be clear and conspicuous. So Hashtag ad, for example, on a social media post would be acceptable, but something like hashtag partner or something that's equally vague would probably not be acceptable. It must be placed properly, and it can't be hidden at the end of a very long hashtag or buried somewhere in the influencer's post. If it's a video that we're talking about, then the disclosure must be made in the video itself. And the disclosure language must be understandable to a reasonable person. Importantly, brands are the ones who are responsible for monitoring and training their influencers. And so in a sense, you need to treat Mr. Beast and all your other influencers like an extension of your marketing team. You should have guidelines in place and make sure your influencers are following them. The FTC has enforcement power over influencer marketing and historically has been taking the lead in this area, but we're seeing, not surprisingly, again, more private actors, plaintiffs' attorneys get involved in this. Just this year, in 2025, we have already seen at least 2 major class action lawsuits filed in US courts. One is against a fashion brand. The other is against an energy drink again, both of them for failure to adequately disclose their paid endorsements. It's important to note that the influencers themselves are often named as defendants in lawsuits. And depending on the type of agreements the company has with the influencer, company might have to indemnify the influencer, right, for the litigation costs. So it's important that both the brands and the influencers make sure that they are abiding by FTC regulations in the US.
And as Arameh said, this does continue also to be a high-risk enforcement area in the UK. We've got both the CMA and the ASA very actively enforcing. The position is somewhat similar, or at least the direction of travel is very similar. Increasingly, it is becoming very, very difficult for brands to not be held jointly liable for problematic influencer marketing. The reality of the situation is if there is enforcement, the regulator will start from the position of the influencer and the brand are jointly liable, and they will ask to see the contract between the same. And unless you have really drafted that very carefully and really stuck to the rules, it is most likely that the brand will be on the hook for whatever the influencer has done. And like in the US, transparency about the fact that it is an ad is, I guess, number one on the most important list. And we also like hashtag ad. It also needs to be prominent. But the things that are also important to remember is that it's not just about ad transparency. That content is an ad and needs to be compliant with all advertising law. And this is particularly important if you're in a regulated sector. You need to be issuing guidance on what claims can and can't be made, and that needs to be contractually binding on the influencer. But the other thing that we're interestingly, the sort of new horizon for the regulators, is they're getting very interested in influencers who have some other relationship with the business. So, for example, they are a non-exec director of the business or they're a shareholder in the business. And they're now saying that you actually have to be transparent about that relationship as well as the fact that they are an influencer. So we have an evolving agenda. And because there's a lot of enforcement, it's evolving quite fast. The other thing that is worth noting is the CMA runs a naughty list of influencers who are non-compliant. So if you are ever working with influencers, it's worth checking their naughty list before you go into a relationship with them. I'm going to just very briefly touch on a couple of things that have come up recently. First one being around reviews. Now, reviews have been a hot topic in the UK from an enforcement point of view for a long time now, many, many years. We're on to, I think, our 4th investigation by the CMA on this. But what has changed in the last sort of couple of months is that this new legislation that introduced the new fines also introduced some new so-called blacklisted offences in relation to reviews. And the one that you need to be really mindful of is the last one on that slide, which is about publishing reviews without taking reasonable and proportionate steps. That basically means that if you use reviews in your advertising, if you have them on your website, even if it's information derived from reviews, such as average star ratings or information which drives the ranking, for example, of results on your page, you need to have a public-facing reviews policy. And that rule came in on the 6th of April this year. The regulator has said it's going to give a grace period of 3 months, so until July, for everyone to get their reviews policy up and sorted. But it does mean, like you have your privacy policy in your footer of your website, there should also, if there are any reviews or reviews information on your website, there should now be a reviews policy as well. And you should have processes in place to kind of review and update that. So that's a new requirement that's come in, and it goes along with additional offences around fake reviews. And then the other one that's a sort of bit of a perennial in the UK is dark patterns, or as we like to refer to them, or our regulator likes to refer to them, online choice architecture. And this is all about nudging or pushing consumers into choices that are not in their best interest. Most of the enforcement is through consumer protection law, but it is worth saying that some of the guidance is also joint guidance with the Information Commissioner's Office. So that's the data protection regulator. So if they use data, dark pattern enforcement could also come through enforcement of UK GDPR or other data protection legislation. The particular focus at the moment seems to be on drip pricing. We've got new rules coming in on drip pricing. We're going to get guidance on what those actually mean over the summer. And also we're going to have a new regime about subscription contracts, which is coming in 2026, which is going to require a lot of software engineering to change the sign-up flow for subscription contracts and also make sure that consumers get lots and lots of new email notifications periodically throughout a subscription, reminding them of their cancellation rights and also that they have a subscription. We are seeing quite a lot of enforcement. Again, we've interestingly got another example. A German company called Emma Sleep is also currently being taken for criminal prosecution in this area. Separately, a UK company agreed to make changes to their advertising and website design instead of criminal prosecution. Always a good option in my view. And we've also got new guidance has come out in the last few months around what we call urgency claims. And that's where you're telling people low stock, or so many other people are looking at it, or things that might kind of push people towards making decisions to buy quickly.
Just quickly, wanted to touch on the fact that similar to the UK, online consumer-facing disclosures are frequently targeted by the FTC, state attorney generals, and plaintiffs' attorneys. And as you can see from the examples on the slide, the consequences for engaging in dark patterns can be costly. And finally, we just wanted to touch on the tariff litigation risks. Although the full impact of the new import tariffs on consumer class actions and regulatory enforcement risks are largely unknown, they are expected to cause supply chain disruption and increase cost to companies selling products in the United States. As a result of this change and the increased cost for companies, there's a few key class action trends that are already anticipated. First, companies that are selling products and services on auto renewal basis should be cautious when raising prices because many state laws require material change notices to consumers with specific requirements regarding the clarity and prominence of the notice. And regulators and private individuals could allege that a price increase is a material change and that companies who raise their prices must notify the existing customer and give them the opportunity to cancel the subscription. Second, some companies are considering added tariff fees to offset their increased costs. For example, this would be a certain dollar amount or percentage surcharge added at checkout. This strategy is likely to be extremely risky because of drip pricing that Katrina previously mentioned and junk fee bans. California, Minnesota, and Massachusetts all have laws requiring businesses to advertise the full total cost of their products and prohibit the addition of further changes or further charges to the advertised price, for example, at the checkout process. This approach, therefore, is likely to result in litigation. In fact, there are already online solicitations from plaintiffs' firms seeking consumers who have been charged a tariff surcharge. And finally, there are increased made in the USA claims that will likely be used to emphasize the origin of a product. And as Arameh already covered, the made in the USA claims must meet legal standards set forth by the FTC and state laws.
If I may briefly touch on a few recommendations, I think we could call them transatlantic recommendations for compliance, Katrina.
I think we could.
Yeah. First would be hopefully obvious. You must substantiate your claims. It's important to ensure that your claims are backed by credible evidence. Second, review labeling practices. Make sure there's nothing misleading in your misrepresentations. If any of your claims might be ambiguous to what we call here in the US a reasonable consumer, include qualifications, define the terms, use qualified claims instead. Understand the laws and comply with the laws. Monitor litigation, and I suppose I would add enforcement trends here. Engage legal counsel before you launch a product to market. As you design a new marketing campaign, engage legal counsel to help you navigate the complex and rapidly changing consumer protection laws in both the US and the UK.
Thank you very much, Arameh, Paige, Katrina. That's really sort of fascinating to hear a compare and contrast of the different regimes and approaches in our two different countries. We are running, well, we've run over time, but there have been a couple of questions that have come in. So for those who are able to stay on, we'll spend a couple of minutes just going through a couple of those questions. Arameh mentioned political climates in the US a bit earlier on during the presentation. Probably unsurprisingly, political climate in the US is of significant interest over here, as it is everywhere else, and some of the questions very much inspired by that political climate. So the first one is more sort of general question, which was how you expect the actions of the current administration in the US to affect the actions and the powers of the federal enforcement agencies.
It's a great question, and definitely one I don't have an answer to, because the only thing I can say about the US climate is that it's unpredictable. We know that the current administration is, I think I would probably qualify it as being less consumer friendly. So I think there's more protection for companies under this administration, or at least that's sort of the message that they're sending to companies. But it's difficult to predict how it will impact federal agencies' enforcement, given that, one day funding is being taken away and the courts are a completely different thing. And so the courts might not be aligned with the federal agencies anyway. So it's really hard to predict right now.
Okay, thank you. A more specific question in relation to the content of the presentation, again from a US perspective. What sort of trends are you seeing at the moment in enforcement of Proposition 65 from private individuals?
Yes, so first and foremost, metals are a big target, often in foods such as shellfish. Phthalates are often used in plastics, and they're in an array of consumer products such as shower curtains, cosmetics, food containers, clothing. Those have been a big target recently. PFAS, the forever chemicals we mentioned earlier, that are used in food packaging, cookware, carpets, dental floss, pizza boxes. Those have been a big target as well. DEA is another one, often found in cosmetics, that have been targeted quite a bit. As I mentioned previously, for example, PFAS and DEA do not have a safe harbor. So these are sort of easy targets by plaintiffs, because it's a lot harder to, negotiate a settlement regarding these chemicals when there isn't a safe harbor that you can provide scientific testing and show that the product is under that safe harbor level for the chemical. And it's a lot harder to reach an earlier settlement without that particular information to shut down the plaintiff. However, it certainly can be done and is regularly done. And the other thing that recently has occurred is that there has been a change to the notice requirements by the government recently. And so that's another thing that is going to require companies to comply with these new short form warnings that require at least one chemical to be identified in the warning. So that's another thing that has recently come about.
Okay, thank you. And another question, and again from a US perspective, and thinking about the sort of the jurisdictional scope of the regulatory position and the jurisdictional scope of enforcement powers. And if we focus again on Proposition 65, does Proposition 65 apply to companies outside California which supply into California? And if it does, what can the authorities do about it if those companies are from elsewhere?
Yeah, so Proposition 65 applies to the actual product being sold into California. So if you're a company and you're taking advantage of I believe we are now the 4th largest economy in the world. California is the 4th largest economy in the world. So the thinking is if you're going to have the opportunity to sell your products into California, then you will be subject to Prop 65. Whether or not you reside in California or have any other contact with California is completely irrelevant. So if you're selling to California consumers, if California consumers can go online and purchase your products, then you must abide by Prop 65. So you must either make sure that your products do not contain any of those chemicals, or if they do, that they're below threshold levels to the extent that they exist, or you must provide a warning. And that's really the challenge, is because most companies do not necessarily track shipments to California separately. It's not like, this batch is going to California and this batch is going to New York. They're all packaged and labeled the same way for the most part. And so the challenge is that you have to make sure that you're including a Prop 65 label on your product, even though that product might end up in Oklahoma. But it's sort of the more cost-efficient way to do it many times, because you don't know. It's more expensive to have unique labeling for each batch, depending on where they're going to end up, even if to the extent you even know that.
And do the enforcement agencies in California have a track record of enforcement against businesses from outside California?
Absolutely. It's not going to stop them if you are not a California corporation. They'll still take your money for violating Prop 65.
Okay. Last question for Katrina. So from your perspective, what is the most important legal differences to be aware of when a US company plans to launch products in Europe?
I think probably the things that I tend to tell my US clients on the first meeting when we chat about launching into Europe, I tend to tell them that we don't get a lot of class litigation going on, and they all go, phew. That's great news. And then I tell them that we have these things. We have a lot of regulation and we have a lot of regulators. And I try and talk to them a little bit about what a regulatory investigation might involve, just to give them a sense that, these things do drag on years. They can cost hundreds of thousands of pounds in legal fees alone. We've now got fines, we've got criminal prosecution. So although there is a big few about the lack of class actions, the regulatory investigations are not to be taken lightly. And we do have a different attitude sometimes to the US, I think, on things like disclaimers. Regulators don't like them. And we also, it's very unusual that a regulator will accept that anything is puffery. So we're much if you like, stricter, I think, in what actually has to go in the advert and the claim itself. And that sort of runs as a theme throughout.
Okay, thank you. Final question again, it's one for Katrina. You can swerve this if you like. You mentioned the influencer naughty list. Are you going to drop any names, or at least tell us where we can find it?
You can find it on. In fact, actually, you know what? We'll send a link to it out with the this. It's actually very short at the moment. There's only about 3 influencers on it. Names escape me right now, but it's worth checking every time before you start contracting with someone, because it's not a great start if they're already on the regulator's radar as being non-compliant. But yeah, we can include a link in the follow-ups. That's absolutely fine.
Okay, great. Well, look, we'll wrap it up there. Some final housekeeping for everybody who's joined us today. Please do complete and submit the feedback forms to provide suggestions for future topics. It's really a massive help for us to have your recommendations. Secondly, very important, thank you very much again to Arameh, to Paige, and to Katrina for all the work that's gone into the prep and the delivery of the session today. Thank you for everybody out there who's attended. We hope you found it useful. And finally, please do look out for an invitation to our next in-house in focus session, which will be winging its way to you shortly. Thank you, everybody.